I am Blinn Bates. I'm an attorney with Woods and Bates. This is a presentation today called Don't Haunt Your Loved Ones, Estate Planning Pitfalls to Avoid. So we're going to be going through several scenarios with everyone, talking about quote unquote nightmare scenarios, if you will. So we want to introduce our panel of attorneys here. Let's just go in order. Brett, I'm going to ask you to unmute here. You want to introduce yourself briefly?
So I'm Brett Green. I'm an attorney here at Woods and Bates. Today, I'm going to be discussing some consequences of using do-it-yourself LegalZoom type documents.
Hello, everybody. I'm Hunter Mitchell, and I'll be discussing the importance of estate planning for blended families, as well as people with subsequent marriages.
And I am Michael Fleshman. I am going to talk to you about the importance of asset alignment with the estate plan.
So that's our panel of attorneys we have for you today. We're going to go through for you just some preliminary information about what your estate is made up of, kind of what a will is, what a trust is. We're going to talk a little bit about our process that we use, and from there we'll go into the three scenarios we have set up for you, and the folks that just introduced themselves talked about those already. And then we will wrap up a little bit with some drafting considerations, things we talk to clients about in our meetings. And then if there's any questions, we will stick around and try to answer some of those also. So I'm going to turn it over to Michael here. He's going to give us a little baseline knowledge on what is my estate.
Thank you, Blinn. So we've got a common phrase in the world called estate planning, and that can mean a number of different things. And what it really boils down to is what you have control over. So that'll be personal property, real estate, any accounts that are in your name, or life insurance policies that insure your life. Those things are considered part of your gross taxable estate. And so when you're looking at a plan, sometimes a will controls the asset, but sometimes it doesn't. And we'll kind of dive into scenarios when the will or a trust would control versus maybe a payable on death beneficiary designation that would control. So estate planning in a nutshell is keeping control over what you have and making sure it gets to your beneficiaries at your death the correct way. And so here's a visual on what is your gross taxable estate. So again, that's anything you have dominion and control over. And we break that out into two different categories: non-probate assets and then probate assets. And you can see that blue box highlighted is your last will and testament. And so you can see that your last will and testament will only control your probate assets. The vast majority of folks' assets can be shifted over to that non-probate category with the right type of planning.
Okay, so on the next slide there, talks about what a will is. That document is kind of a cornerstone document of estate planning. And so what we've defined a last will and testament as is a document by which a person directs his or her estate to be distributed upon death. That will can do a lot of things, but a will by itself has to be probated, has to go through the court process, which is known as probate. That process can be lengthy, it can be costly, can be cause delays, time consuming. But what happens is that will nominates an executor to act, and that executor would be appointed by the court through the court process. And what the executor does is whatever that will says, that's their job to do. So they wind up the affairs of the deceased, pay any debts, distribute any assets according to that will. That will can do some other things like create trusts, or can nominate guardians of minor children if that's an issue. But that will is pretty robust and it can do a lot of things. That is a little bit different than a trust. So when we talk about a trust, the trust type that we are talking about today is a living trust. And so that's a trust that would be created during a person's lifetime. The way that works is that trust is created and property that the person owns is retitled into the name of the trust. So we transfer real estate, we transfer personal property, we retitle bank accounts, whatever needs to be done to fund that trust. And then that trust document is going to appoint a trustee A lot of times that's the person creating the trust, and this process does not negate the need for a last will and testament. So we're still going to have a will when we have a trust, but that will is going to say, probably I leave everything I own to my trust. We refer to that as a pour over will. This process, if done correctly, which you're going to see here in a little while, there are certainly scenarios where it's not done correctly, but if done correctly, it should avoid the need to probate a will. There are pros and cons to each will-based plan or a trust-based plan, but if somebody dies without either, they're known as having passed away intestate. So they've died without the will, and then the laws in our state of Illinois, pass those assets on to whoever the statute says gets to inherit. So that is typically not the best plan. We have established a process in our office. There's a QR code on there. If you want to pull that up, that links to more detailed description of our process. But our process that we follow is pretty standard when we do estate planning. We call that the 7-step legacy builder process. And so, again, that document's linked on our website. But as an overview, what we do in that process is when a potential new client calls the office, we will get them set up with an online portal where they're going to submit some information to us. We're going to gather that, and that information is going to help us when we meet with that individual, which is the next step. We're going to schedule that assessment. We call that a legacy assessment meeting. And we are going to discuss all of the things that Michael and I have just talked about. We're going to discuss, ownerships of assets, what we think the best course of action is, what we're going to charge to do that work, if we want to move forward with that work. And then once we have had that meeting and once we're engaged to do the work, we're going to draft documents, send those to the client to review, and then we'll meet with the client either by telephone, in person, by Zoom, whatever the case may be, to discuss questions, any revisions that need to be made. Then we're going to have a meeting to make those documents official, get them signed, make sure they're witnessed appropriately, notarized appropriately, which you're going to see in a few minutes can cause a lot of problems if that's not done correctly. And then finally, ongoing review, which we're going to talk a little bit about later also. So that's our process at our office. That kind of leads us in now to our first scenario, which is called the do-it-yourself ghostwritten will. I'm going to turn it over. I believe this one is Brett.
So thanks for the introduction, Blinn. I have a client with me today who has brought in her sister's will. This looks like it may have been a self-drafted will or a LegalZoom drafted will. Let's talk to Janet and see what some of the details are here. What's in this will, Janet?
Good afternoon, Brett. My sister was a very private person. I rarely spoke with her. She had no spouse and no kids, so I was contacted when she passed away because I was her nearest relative. While going through her things, I found this will. It looks like she used some website. I see commercials about these websites on TV sometimes. From what I can tell, she gives everything to the Haunted Hearts of America Foundation. How can you help me?
Haunted Hearts of America, huh? Well, this situation is going to highlight the importance of ensuring that all of our legal documents are correctly drafted, in line with Illinois statutory requirements, and that it's going to be an effective and legally valid will. Now, a self-drafted will or a LegalZoom type drafted will can be an effective legal document if it meets all the statutory criteria, witnessing criteria. So, in this case, there's several possible pitfalls that a self-drafted or LegalZoom type will can run into. If we fail to meet Illinois execution requirements, that will can be declared invalid. Illinois requires 2 credible witnesses to have signed the will in the presence of the testator and in the presence of each other. The will must be signed by the testator. A do-it-yourself will does not ensure that these conditions are met. This could lead to a situation where a court could declare a will invalid, and we could now be in an intestate situation. Another common pitfall that I see in these online type draft wills is oftentimes interested witnesses will be used. If a witness that signs the document is also a beneficiary, the gift of that will, bequest to that beneficiary, is going to be void. This can create a situation where your assets are not being distributed as per your wishes. They're going to be distributed by Illinois statute. Oftentimes also I'll see that these self-drawn up wills, they're missing residuary clauses. When I draft a will, I make sure that we compensate for a situation where the primary beneficiary may predecease you. If we don't address this in the will, again, your assets may end up being distributed in a way that you didn't expect. And ambiguous and contradictory language. If we have contradictory language in a will, the court is going to interpret that language to the best of its ability. And that's going to be what happens with your assets. We want to avoid a situation where we have the court determining where your assets are going instead of the testator. Overall, these self-drawn up wills, LegalZoom type wills, they can create a false sense of security. These do-it-yourself wills can look official, but fail legally. The last thing we want is a family discovering after a death that will is invalid and that assets are not going to be distributed as the decedent wished. We don't want a situation where a client is spending $50 on an online will, and that savings that they think they're getting is going to end up costing them $50,000 in litigation down the road. Having an attorney draft your will, talk to you about your estate plan, can avoid all of these pitfalls and make sure that will is going to be valid. Now, Janet, did you say that your sister was never married and had no children?
Correct. She was my only sibling. Both of our parents passed away when we were young. Why does that matter?
Okay, so in a scenario where her self-drawn up will might be invalid, Illinois intestacy statute is going to take over. In your sister's case, that statute would first direct her assets to a spouse and children if she had them. She doesn't. Then it would direct those assets back up to your parents who are deceased. Your parents being deceased, the assets would be distributed next to siblings. That would be you. Under an intestacy situation here, we can see that the assets are not going to get to the charity of choice. Janet, you are going to inherit all these assets, like it or not. If you have an attorney help you in drafting, these types of situations can be avoided.
All right, thank you.
So I think it's pretty crucial to work with somebody that knows what they're doing, make sure that assets are going to go where they're supposed to go or where the client wants them to go. Brett had indicated that so can a person draft their own will, Brett?
So a person can draft their own will in Illinois, and it can be legally effective. If a person is going to draft their own will, they need to be aware of all the Illinois statutory requirements, execution requirements, the witness requirements. They're putting themselves in jeopardy by not getting professional legal advice that the instrument is not going to do what they want it to do, although it could if properly executed.
There are some jurisdictions, Illinois is not one of them, but there are some jurisdictions that allow what's called a holographic will, which is somebody writes it in their own handwriting and they sign it. And that is valid in some states. It's not valid in our state. Still has to be witnessed by two uninterested witnesses. So that's important. And there are other scenarios that come up where will could be successfully challenged. If somebody signing a document isn't competent, or if they're under undue influence, if somebody's pressuring them, the formalities are only one thing, but we have a process in place where we ensure that the person is of sound mind, that they know what they're doing, that they're not under any undue influence. We make sure all those things happen so that the likelihood of a successful challenge, at least, is very, very minimal if they're signing documents. So I think that's really important. Brett, Janet, we appreciate the information. I think the next scenario is the ghosts of marriage past and present. And I'm going to turn it over on this one to Hunter.
Hello, and thank you. Today, I have a client with me, and her father passed away. The client's father has been remarried after his wife and the client's mother passed away previously.
Need to unmute here. Just give me a second.
Hello, Attorney Mitchell. My father recently passed away, and all of his assets were jointly owned with his second wife. I don't really speak with her or get along with her because of how quickly my father married her after my mother died. He had a will, but left everything to me, his only child. Now I'm trying to figure out what I need to do to make sure that my dad's wishes are followed.
Thank you for coming in. This is a situation we see quite often. First off, I'd like to thank you for completing the intake form that we gave out prior to our meeting. What this does is it allows me to review your dad's assets and, most importantly, determine how those assets were owned. If I see that dad had ownership in some farm ground, or I see that your dad did have some ownership in some farm ground. After he remarried, he deeded this farm ground to himself and his new wife as joint tenants with rights of survivorship. Because of this deed, his second spouse has survivorship rights to the farm ground, and your dad's will not control the distribution of the farm ground.
Are you kidding? I live on that farm ground. I live at that homestead. What do I do now?
Well, unfortunately, your dad's surviving spouse has no obligation to allow you to continue to live at the home. If the surviving spouse will not voluntarily gift the house to you, then you would need to place it in, or then you would need to purchase it from them at an agreed upon price.
Oh, this is bullcrap.
And I have some worse news.
Oh, no.
It looks like the title to dad's vehicle was also jointly owned with his second wife. Along with all of his bank accounts, they were either jointly owned or his second wife was the primary beneficiary on these accounts.
So what do I get?
Don't shoot the messenger here, but it appears you will get nothing from your dad's estate. If the second wife wants to play nice, she could make a bunch of gifts to you and gift all the assets to you.
Oh, yeah, right. She's a witch. Thank you for your time.
Thank you.
So this is a prime example of someone's failure to plan to accomplish what they wanted to accomplish. I doubt that it was the intention of dad to leave out the daughter altogether, which is probably what's going to happen in this scenario. So, what other questions do you have, Hunter, for that scenario? Like, what if dad would have come in and seen you ahead of time, what would you have recommended?
I would have recommended that he sets up a living revocable trust that would allow him to take care of his spouse for the remainder of her life while preserving the assets for the children.
I think that's a good plan. I think I have seen before also where premarital agreements can come into play there. That's a situation where in second marriages or even in first marriages, people are agreeing these are the things that we're going to take from the marriage in the event of death or in the event of divorce. These are the things that we're going to keep, for the benefit of my children, and that would help with any statutory claims the spouse might have after death, to make sure that those types of scenarios don't happen, that those need to be done in advance. They need to be thought out. And, there's ways that Aaron's dad could have provided income to his second spouse and still gotten the bulk of those assets to his daughter, but it takes some planning in advance. Okay, well, thank you guys. We are going to move on to our last scenario here.
All right, scenario number 3, rest in peace if your assets are aligned.
There it is. Got it.
So I have a couple of clients with me today, and their mom passed away, and mom was pretty wealthy, and they're looking for a little bit of direction. So sisters, how can I help you today?
Our mother passed away last month, and we're trying to sort through her things. Of course, she had a significant amount of wealth.
Do you know if the total of her assets exceeded 4 million?
Whoa. Add another 0 to that figure, darling. We don't do anything under 9 digits.
Oh, wow. Okay, so she had a $40 million estate. Is that
Yes,
right?
that is correct.
Okay.
So, Daddy, who is deceased, was one of the founders of Prestige Worldwide. I'm sure you've heard of them.
I have. I have. Okay, so did mom have any ownership in that business when she passed away?
My sister and I have ownership of that company now. So we were told my mother did not have to leave anything to us.
Okay, and so again, thank you for filling out that intake form ahead of time. I was able to review the trust that your mother set up, and it looks like your mother's trust skipped the two of you and left all of her assets to charitable entities. Looks like she listed about 15 of them.
Our mother was very philanthropic.
That's a very great mindset to have. Let's take a look and see what is owned by the trust and what that
Whoa,
trust can
sorry,
control.
I must be confused. I thought our mother's trust automatically owned everything.
Well, that's not true. So in order for your assets and accounts to pass according to your mother's trust, the trust must be properly funded.
You need to explain what that means. How do we fund this trust?
Well, you guys can't fund mom's trust after her death. She would have needed to ensure that the trust owned the assets or that the trust was the primary beneficiary on any account that was in your mother's name.
Our mother added us to her investment accounts as joint owners after our father had passed. She wanted to make sure we could help her if she was unable to make any financial transactions on her own.
Well, because those accounts were jointly owned, that's going to create a right of survivorship. And now the two of you are the owners of those accounts, not the trust.
Our mother had a significant retirement account. Will the trust control that?
Well, do you know if that retirement account had a designated beneficiary on it?
Yes, Daddy was the primary beneficiary. There was no one listed after him.
Well, most likely that account's going to be paid over to your mother's estate by default since there was no contingent beneficiary listed. So now her will is going to control that since it's passing through your mother's estate. I didn't notice that that you uploaded a will for mom in the intake process.
We didn't think you needed a will if we had a trust.
Well, that's unfortunately not accurate. And through our process, what we like to do is set up a document called a pour over will. And that's designed to catch anything that might fall through the cracks, like your mother's retirement account. So, because your mom didn't have a will, we'll have to discuss the intestate laws for Illinois. Because you are the surviving children and your mom does not have a surviving spouse, the two of you are going to equally inherit that retirement account through probating mom's estate.
So, what does our mother's trust control?
Well, it doesn't look like it really is going to control anything. It didn't own any assets and it wasn't the beneficiary. So now what this has also led to, unfortunately, is your mom's charitable beneficiaries that would have helped avoid or drastically reduce any estate tax that mom would have had due to the reason or at the reason of her death. And now, because those assets are either jointly owned by you or will be payable to you through her estate, it's going to be subject to a pretty large and hefty estate tax, both federally and in the state of Illinois.
I would say on a $40 million estate, you're looking at probably $10 million of tax federally.
It's pretty punitive there.
So this is an example, I think, of why it's important to look at everything that someone owns and align everything with the plan. So everything has to be aligned with where we want the assets to go, how we want the assets to be owned, who we want the beneficiaries to be, and that joint ownership is really, really important also. We get questions a lot about should we change, should we put my name on the account so that it's easier to write checks, and that may or may not be a good idea depending on the situation. It's more of a holistic look at everything. What if this client, Michael, would have come in before she passed away, what would you have advised her to do at that point?
Well, one of her concerns during her lifetime was making sure that her kids had access to her investment account for convenience purposes. So rather than making the kids joint owners, I would have recommended that mom put a power of attorney for property and finances in place. She could have nominated one of her kids as the primary agent and still have access to that account. Leave that account in mom's individual name, or better yet, transfer ownership of that account into the trust while mom's alive. And now mom's trust can allow for a successor trustee to step in and manage that account without affecting the ownership or the distribution of that trust account.
I think that would have been a good plan. I think those assets then would have gone to the charitable beneficiaries and probably reduced, if not eliminated, the estate tax at that point.
Yeah, and I think one very important lesson to learn from this scenario too is constantly review how accounts are owned and how beneficiaries are listed. And so when a life event happens, like the death of a spouse or a death of a child, it's not a good time, but it's a good time to think about beneficiary designations. So in this scenario, mom could have gone out and looked at that retirement account and noticed that dad was the only beneficiary, her spouse, and that since he was predeceased, she needed to update those beneficiaries. If she wanted that account to pass through the trust, then she should have named that trust as the primary beneficiary on that retirement account as well.
I think that's good sound advice. We talk with clients routinely about a lot of these things. Michael, you want to go through some of the things we talk about with clients at our client meetings there?
Yeah, so the focus of this presentation and the rules that we're talking about apply to the state of Illinois. So in Illinois, there is an estate tax that's assessed on somebody's estate after it exceeds $4 million. Federally, there is also an estate tax, but it doesn't get triggered until after 13.9, I think $13.99 million. So there's a lot more people that are in that Illinois estate tax danger zone than what they may realize. And so part of our process is having the client compile a list of assets and what their fair market value are. So during that planning session, our initial legacy assessment with the client would allow for us to contemplate estate tax issues and then plan accordingly. And then once we design what plan is best for the client, we'll talk about who the ultimate beneficiaries are. Sometimes a beneficiary may be a disabled individual, or maybe needs to be protected from themselves because they're a spendthrift or are suffering from some type of addiction that would not be in their best interest to inherit outright. So we'll go over the family dynamic and look at every client's situation, not just in a bubble, but kind of look at it logistically. What happens if somebody dies, and play some hypotheticals and figure out where assets would go. And then the most important consideration is, who do you trust and who do you want to nominate to take on that role of making sure your wishes are followed whenever you're not able to, whether because of death or whether because of disability or age. And so a couple of additional things, part of that legacy assessment process, is we'll go over your family dynamic. If you have minor children or disabled beneficiaries, then we'll make some plans to provide and care for those beneficiaries with having the least amount of negative effects. So we've got a situation where a minor child maybe was going to inherit and be the beneficiary on a retirement account. Maybe that's not the best way to do it. Maybe a trust would have been more beneficial, so that a trustee could manage those assets for the minor child until they reach a certain age or until they reach a certain benchmark in life. And so one thing to consider with people that have young children is, if something happens to me today, me and my wife today, we've got 15 years until our youngest child is of the age of majority. So there's a potential that whoever I nominate in that trustee role would need to take on that position for a considerable amount of time. And so one thing we discussed too is, if your original or initial trustee is unable to continue on acting, who do you want to step in as a backup to that person? The last thing we talk about, or another thing that we'll talk about in that drafting legacy assessment meeting, is, do you have specific family heirlooms or pieces of personal property, jewelry, firearms, artwork that wants to go or should go to a certain person or certain people, and we'll plan for that as well. Glenn, I think if you go back to slide number 5 that has that gross taxable estate, that's a really good visual that we didn't really dive too deep in. So we noticed today in all of these different scenarios, it's very possible that each scenario could have passed through that non-probate column or that non-probate group. And so the first question of, do you have a joint owner on the account? That was scenario 3. We had 2 children as joint owners, that those surviving joint owners automatically inherited. It didn't matter what a trust or what a will said. The next question is, does the account have a beneficiary? We saw that as well in scenario number 2. Hunter's client remarried and had the subsequent spouse as the primary beneficiary on all of the accounts or as a joint owner. So that beneficiary inherited. And then back again in my scenario with the trust, the primary question there is the asset owned by the trust? Not does a trust exist, but is the asset owned by the trust? And that's where the asset alignment comes in and really is one of the most important parts of planning.
So I think just in summary, there's a lot that can be learned from these scenarios, but mostly everyone's scenario is different. So everyone's circumstances are different. The ultimate result that the client wants is different. Their goals are different. Some people's goals may be to reduce tax as much as possible. Other people's goals may not really care about the tax. They may have other considerations, but each plan needs to be tailored to the individual and their specific needs and wants and goals. And one of the big things I think that gets lost a lot is reviewing those plans when things change. So birth, death, divorce, disability, all of those things, all those life circumstances, things do change. We have tailored a program at our firm called the Client Care Program, and CARE is an acronym, but basically what it is our clients sign up for that program, and then we will meet with them twice a year to do a couple things. First and foremost, make sure that the assets remain aligned with the plan and that the plan is still the way that we want it. So kind of housekeeping type things on an annual basis to make sure when things do change, the plan changes with it, the asset ownership changes with it, things are going to go where they're supposed to go. And then as a corollary to that, getting the decision makers, be it the children, financial advisors, accountants, whoever that is, into a meeting to make sure that everybody's on the same page and knows what's happening or what's going to happen or what we want to happen or why we want it to happen. Why are we making these decisions? Because when there are surprises, that is typically what leads to litigation, and litigation typically reduces the value of what's there for the beneficiaries. The lawyers are the ones that win in litigation every time. So we believe that everyone should make their wishes known while they're living, and to avoid that confusion, avoid that feuding when they're gone, and then everybody knows what's going to happen. Everybody's on the same page, and we're just ready to make that plan work. So there is another QR code there that will link to information on our website about the Client Care Program. The CARE stands for check-in, asset alignment, review, and education. So that's what those letters stand for. If you have any questions about that or anything else we talked about, that will conclude our presentation for today. We are glad everyone joined us. Happy to have you. If you do have questions, you should be able to unmute yourself if you want to, and you can just ask those now. We'll hang out here for a couple minutes and see if there are any questions. Thanks again.
This is our second annual spooky themed Halloween webinar. Try to look at some experiences that we see that clients have and figure out that they're not that uncommon of issues that we run into, but they're issues that can be easily avoided.
Right. Doesn't look like we have any questions. Last call. All right, I'm going to end it. Well, thank you guys for joining us. And if we can be of any assistance, or you have any questions that you want to discuss with us individually, feel free to give us a call, and have a good afternoon.